Today, in the media conference with Lal Goyal, which is brought to you by V4 News, Karu News, V4 Stream, Malnadu TV India, News Gaon Se, Samvad Sarokar News, Bharat Post News, Gyan and Organ Donation India Foundation. Our endeavor is to enlighten you with the current topic, and today's topic is not only current, very sensitive, very controversial. The topic is, can judges be criticized? Does the Constitution gag general public from criticizing a Supreme Court or a High Court judge for a noticeable incorrect observation or decision? Or this will be contempt of court. Contempt is the power of the court to safeguard its majesty and respect. This power is inherent and is recognized in the High Courts and Supreme Court's constitutions. The Contempt of Courts Act of 1971 regulates but does not limit this power. Both civil and criminal contempt is defined under the 1971 Contempt of Courts Act. Civil contempt refers to willful disobedience to any court judgment, whereas criminal contempt can be invoked if an act tends to scandalize or lower the authority of the court or tends to interfere with or obstruct the administration of justice. Any publication that scandalizes or lowers the authority of any court qualifies as criminal contempt under Section 2C of the Contempt of Courts Act 1971. These are broad and vague expressions, but the Supreme Court has underlined that reasonable criticism of decision is always permitted and that defaming a judge is distinct from contempt of court, as held in the case of Brahma Prakash Sharma versus State of Uttar Pradesh, 1953. According to Section 5 of the Act, fair criticism or fair comment on the merits of a final decision does not constitute contempt. The judgment of what is fair is, however, left to the judge's opinion. Before 2006, even the truth could not be used as a defense in a contempt case. The truth has been included as a defense with the enactment of the Amendment Act of 2006, but with the restriction that it can be used as a defense only if it is in the public interest. The judge has complete discretion over what constitutes public interest. The truth cannot be used as a defense unless the supposedly contemptuous behavior was both genuine and in the public interest. And to discuss this very, very important topic today, we have a very elite legal luminaries with us. And I would like to invite my first panelist guest, and he is Honorable Justice Rajiv Lochan Mehrotra. Honorable Justice Rajiv Lochan Mehrotra is the former Allahabad High Court judge. He is the chairman of Review Committee, which looks after Prevention of Unauthorized Activities Act. He joined services as civil judge. He worked as district judge at Bijnor and Agra. He also worked as judicial member, State Administrative Tribunal. Welcome, Honorable Justice Rajiv Lochan Mehrotra on our show. Honorable Justice Mehrotra, this topic we have taken because you have also seen in the media for last almost a week or so much criticism is coming, even on the social media. Even some application have been made to the CJI because some observations were made by the two sitting Honorable Supreme Court judges, which were not according to the petitioners or those who have filed the application, or some former judges, former bureaucrats, former defense army pupil. They all filed with open letter they have written. As well as last week only, or rather this week only, one of the very senior police officer has filed a review petition. I will not say review petition, a petition asking to delete the remarks made by one sitting Karnataka judge. According to him, it's scandalous and it is not correct to impinge some exertions on a government appointed senior bureaucrat as well as a government agency, that is Anti-Corruption Bureau. So the media is taking it in a different way, but our aim is to analyze whether in India can judges be criticized or not? So, can judges be criticized? Honorable Justice Rajiv Lochan Mehrotra.
नमस्कार सभी को। ये बहुत सेंसिटिव टॉपिक है आज का, और मैं इसकी शुरुआत केवल यहाँ से करना चाहूँगा कि देश में चाहे श्रीमती गांधी का इलेक्शन आपने देखा इमरजेंसी के पहले जिस तरह से सेटिसाइड हुआ, या इसके अलावा अयोध्या इशू को जिस तरह से सुप्रीम कोर्ट ने निपटा लिया, उसके बाद से कोई रिजेंटमेंट किसी भी सेक्ट की ओर से, किसी भी रिलीजन की ओर से, पब्लिक की ओर से बिल्कुल नहीं हुआ। ये चीजें ये दिखलाती हैं कि अभी भी हमारे सिस्टम में लोगों की आस्था जुड़ी हुई है, और एक ऐसा सिस्टम है जिसमें पब्लिक जिसके जजमेंट्स को या जिसके ऑर्डर्स को पब्लिक किसी न किसी रूप में मानती है। अब इस सिस्टम को कैसे बचाना है, कैसे इस सिस्टम पे हमको कैसे इसको प्रिजर्व करना है, इस पे इसीलिए मैंने कहा कि ये बड़ा सेंसिटिव टॉपिक आज का है। देखिए, कहा गया है, शुरू में भी आपने देखा इंडियन कल्चर में, और पुराने कवियों ने कहा, निंदक नीरे राखी। निंदा करना किसी को अपमानजनक नहीं लगता है, ये हमेशा आदमी के अंदर की इनहेरेंट क्वालिटी को इम्प्रूव करता है। सुप्रीम कोर्ट के जजमेंट्स आप देख लीजिए, 47, 48 के बाद से लेके आज तक न जाने कितनी बार सुप्रीम कोर्ट ने अपने जजमेंट्स को रिव्यू किया है और ये माना है कि नहीं, वी वेर रॉन्ग एट दैट टाइम, और करेक्ट इसको ऑब्जर्वेशन, करेक्ट इंटरप्रिटेशन लॉ का आज की सिनेरियो में ये हो सकता है। सुप्रीम कोर्ट अपने जजमेंट्स को ही रिव्यू करके बार बार उसको लगातार रिफाइन करती जा रही है। केशवानंद भारती का केस, गोलकनाथ का केस, सारे केसेस ऐसे हैं। केशवानंद भारती में आपने देखा कि 13 जजेस की बेंच 7:6 पे डिवाइडेड थी, माने कि कुछ इस तरफ थे, कुछ उस तरफ थे, लेकिन जिधर मेजॉरिटी थी हमने मान लिया कि वो जजमेंट होगा, और हमने मान लिया कि बेसिक स्ट्रक्चर उसका चेंज नहीं हो सकता है, और पब्लिक ने भी एज इट इज उसको मान लिया, और हमारी पार्लियामेंट ने या एग्जीक्यूटिव ने भी उसको ओबे किया। तो अब ये सवाल इसका है कि क्रिटिसिज्म कैसी होनी चाहिए। क्रिटिसिज्म हमेशा ऐसी होनी चाहिए जो हमारे सिस्टम की डिग्निटी को, उसकी अथॉरिटी को डिमीन ना करे, लोअर ना करे, और ऐसा ना हो कि कल पब्लिक जजेस को ही एब्यूज करना शुरू करे और कोर्ट रूम में घुस जाए, और उसके बाद फिर नेक्स्ट सिनेरियो क्या होगा। इस डेमोक्रेसी में आज हम देख रहे हैं कि हर एक्शन का दुगनी वॉल्यूम से रिएक्शन हो रहा है, तो उसको सेव करने के लिए इस सिस्टम को बचाए रखना बहुत जरूरी है। एक बहुत नैरो लाइन बनाई गई है क्रिटिसिज्म पे और कंटेम्प्ट के बीच में। क्रिटिसिज्म अगर जजमेंट का होता है, क्वालिटी ऑफ जजमेंट का हो रहा है, ये कहा जा रहा है कि ये जजमेंट पुराने जो सेटल्ड लॉ है उससे डेविएट करके दिया गया है, तब कहीं पे ये कंटेम्प्ट की श्रेणी में नहीं आता है। लेकिन अगर आप ये कहना शुरू कर दें कि ये जजमेंट तो किसी पर्टिकुलर पार्टी को, किसी पर्टिकुलर इंसान को खुश करने के लिए या अगेंस्ट सर्टेन कंसिडरेशन दिया गया है, तब निश्चित रूप से ये कंटेम्प्ट की श्रेणी में आ जाएगा। कभी आपने देखा होगा कि सीनियर एडवोकेट श्री प्रशांत भूषण जी के आपने पिछले 2 पुराने ऑनरेबल सीजीआई साहब के जमाने में देखे थे, जब वो एक मोटरसाइकिल पे बैठ के उन्होंने एक फोटो उनकी वायरल हुई थी, और उसके बाद ये प्रशांत भूषण साहब का एक स्टेटमेंट था जिसमें उन्होंने कहा था कि डेमोक्रेसी को ये सिस्टम पूरा फिनिश किए दे रहा है। तो वो कहीं ना कहीं कंटेंट में, चूंकि उन्होंने उस सिस्टम को पूरा डिमीन करने की कोशिश की थी कि ऐसा लगता है कि हम लोग या पूरा ये जो जुडिशियल सिस्टम है ये डेमोक्रेसी को खत्म करने के लिए आमादा है। ये कंटेम्प्ट की श्रेणी में निश्चित रूप से आएगा, क्योंकि इसकी वजह से आपने पब्लिक में एक मैसेज देने की कोशिश की है कि शायद हमारा जुडिशियल सिस्टम इम्पार्शली काम नहीं कर रहा है। तो मेरा अपना आज भी मानना है कि अगर ये हेल्दी क्रिटिसिज्म है, जस्ट टू इम्प्रूव द जजमेंट्स है, तो ये कंटेम्प्ट नहीं है और ये परमिटेड है और ये हमेशा होते रहना चाहिए, जिससे कि क्वालिटी ऑफ जजमेंट्स इंप्रूव हो सके। अब अभी जो रिसेंटली हम लोगों ने देखा, एक बेंच के कुछ ऑब्जर्वेशंस थे। मुझे नहीं पता कि बाकी हमारे जो पैनलिस्ट हैं या बाकी स्पीकर्स का क्या उसमें रिएक्शन हो सकता है, लेकिन हम आज भी मेरा ये अपना एजम्पशन है कि अगर इन राइटिंग कोई ऑर्डर नहीं है तो इट शुड नॉट बी टेकन इनटू अकाउंट और उसको उतना सीरियसली नहीं लेना चाहिए। दो आई थिंक कि जजेस को बहुत ज्यादा ओवर एंथुसियाज्म में नहीं बोलना चाहिए। शायद मतलब मेरा ऐसा अनुमान है कि जजेस को इस तरह से रिएक्ट नहीं करना चाहिए जिससे कि पब्लिक को कहीं कोई शक हो पाए कि हम किसी और बायस्ड हैं या कुछ हमारे इंटेंशंस आपके हम या हमारी नाराजगी है। लेकिन उस किस्से को बहुत ज्यादा तूल नहीं देना चाहिए मेरी अपनी राय में, क्योंकि जजेस ने उस बारे में कुछ भी लिख के नहीं कहा है। सिंपली उन्होंने एक आपका पिटीशन खारिज किया है और इसके बाद भी अभी अगर आप उस बेंच से नाराज हैं तो किसी और बेंच के लिए ऑनरेबल सीजीआई साहब के रिक्वेस्ट कर सकते हैं कि इट बी लिस्टेड बिफोर अनदर बेंच। रोस्टर चला करता सुप्रीम कोर्ट में है। तो मेरा अपना आज भी जो एसेसमेंट है, जो मेरा अपना आज भी सोचने का ढंग है, उसमें क्रिटिसिज्म ऐसा न हो जिससे कि पब्लिक में सिस्टम के विषय में उसकी क्रेडिबिलिटी खत्म हो जाए। और एक बार अगर इस डेमोक्रेसी की एक स्तंभ की, जो इट इज वेरी इंपॉर्टेंट पिलर ऑफ द डेमोक्रेसी, अगर इसकी क्रेडिबिलिटी खत्म हो गई तब सोच के भी डर लगता है कि क्या होगा। थैंक यू सो मच। बाकी नेक्स्ट राउंड में।
Okay, thank you very much, Honorable Justice Lochan, for your Mehrotra, for giving your views. Yes, Justice Mehrotra, Honorable Justice Mehrotra mentioned very clearly that criticism is required. He mentioned about Nindak Niyare Rakhiye, but he says it should be a healthy criticism or something which is really required, not to demean any system or any government or any system. So, according to him, and he has given the example of the advocate Prashant Bhushan's contempt case, where he has put something about the motorcycle used by the former CGI. But although he has mentioned, but I would like to just say that there are few things which have happened, and even the people were kept mum, like some committee, sexual harassment committee was not in place at the Supreme Court. And nobody has criticized that very thing, which is if the Supreme Court is not observing or accepting their own laws, then how the public will also observe. That was one thing which has become a very controversial thing. But anyway, but he says that current situation, which we are seeing for last 8-10 days, where so many former bureaucrats, former judges, and everyone is saying that the observations made by the current sitting honorable Supreme Court judges are not acceptable, not good, not in a good light. But according to him, even if they have made some observation, we should not limelight it. We should not give that much importance. And he says that that judges should also be a bit cautious, not to overreact something, although it's an observation, it's not an order. And he says the solution is that you can move to the CGI and ask for the change of the bench, but not to criticize or scandalize rather this type of things in the public at large. If the public will start accepting this and they will feel that our judges are doing wrong or they are favoring or not favoring any particular party, then it will be very, very bad for the democracy. Thank you very much, Honorable Justice Mehrotra, for giving your very, very strong views and clear views about the today's topic. Thank you very much. Now I would like to invite my next panelist guest, and he is Advocate Shashank Deosudhi. Advocate Shashank Dev Sudhi is practicing in Supreme Court, New Delhi and various high courts of the country for over 20 years. He has been appearing in the courts for public causes besides commercial litigations across the country. He appeared in more than 50 public interest litigations, which includes health issues, education, environment, aviation issues, etc. He has also raised the issue of free testing of COVID-19 to all citizens in the private as well as government labs across the country as petitioner. He has also raised the issue of regulation of airfares by way of PIL in Delhi High Court. He has also raised the issue of Shaheen Bagh protest in Honorable Supreme Court on the ground the fundamental right of common citizens should not be violated and several other issues which are in the public domain. His life is dedicated to millions of masses who are in need of the justice. Welcome, Advocate Shashank Dev Sudhi on our show. Advocate Shashank Dev Sudhi, you have heard what Honorable Justice Mehrotra has mentioned. And he has given a very balanced view about the criticism of the judges. You are appearing in the courts. Honorable Justice Mehrotra was sitting on the other side. You are from the other side. And you are seeing the behavior of the judges every day whenever you are appearing in front of them. We would like to know from you, and many times it happens that the judgment or the order or the observations are not for the liking of one party, might be liking for the other party. But the question is, our topic is today, can judges be criticized? Advocate Shashank Dev Sudhi, please. Please unmute. Please unmute.
Good morning, Mr. Lal, and good morning, Justice Rajiv Ji, my brother Gagan, and lady advocate, it's a good morning to all of you. It is undoubtedly a very debated topic, and in the today charged and explosive circumstances, the topic of contempt has become more relevant. And as Mr. Lal had in the beginning, quoted several cases with respect to the contempt of the court. So I'm not going to the exact intent and the meaning which had been defined by the several courts in the several judgments, because it will be the unnecessarily waste of time. But one thing which I must say to you, that the contempt of the court is the power of the court to protect its dignity and majesty, and because that is most important, primarily because the court cannot function without any protection and without really power to regulate the affairs of the court. So this power is basically given to the court to regulate the proceedings of the court, as well as the post proceedings of the court also, because the fair criticism and criticism, now every people criticizes, and the judgment are now subjected to be criticized every now and then. But unfortunately, the expression of contempt of court has not been defined by the Constitution. The Contempt of the Court Act 1971 is silent about its definition. But in nutshell, it can be stated that it is basically to protect the majesty and the honor of the court. But I would like to say something, because all these controversies started after the Nupur Sharma case hearing in the Honorable Supreme Court in the recent, very highlighted case. And the honorable judges have spoken something which, as per the law, it is my personal view, as per the law, it is well settled law that the presumption of innocence of the accused until proven guilty. And if they are following the jurisprudential philosophy of the criminology, the Honorable Supreme Court should not have said this line that Nupur Sharma had, spread hatred. Of course, it may be individual opinion, but whatever has happened in the court and after the our observation made in the court, there was a criticism all across social media, mainstream, off-stream media, everywhere there criticism. It should be not done, no doubt about it, because the court proceedings is all about the legitimacy of the proceedings and the public faith and trust in the court proceedings. If that trust is being eroded systematically by the criticism, then it is affront and offense under the provision of the Contempt of the Court Act, because the trust of the people must not be eroded in the judiciary. That is the whole hallmark of the Contempt of the Court Act. Individually, we can criticize the judges. It has been let down in the several judgments, but that is not related to the judgment. That is not related to the legal point. Individually, a particular judge is having some questionable behavior. Definitely, those judges can be criticized, and for that, the judges has a legal remedy of initiating a proceedings under the ordinary law. But as an institution, you cannot criticize the court and judges. Judges may be wrong, but it does not mean that you criticize willfully, because there should be fair criticism, and fair criticism is allowed under the court everywhere. And what is fair, it is again not defined. So the entire conflict revolves around the subjective interpretation of fairness. There must be objective interpretation of fairness. So what I am trying to say that if one hand, there is a freedom of speech and expression under Article 19(1) of the Constitution of India. And similarly, by the same token, there is a restriction under Article 19 subclause 2 of the Constitution of India, reasonable restriction. So the intent of the Constitution is very clear that if you speak, if you criticize within the domain of the constitutionality, within the domain of the statutory premises. You cannot criticize the judges or anyone beyond the permissible limit of the law. And yes, of course, the judges are, the judicial institution are more sensitive, because every day the judicial institution are pronouncing judgment of great significance. So definitely the all eye is towards the judiciary, because the checks and balances responsibility has been entrusted to the court. So therefore, the onerous responsibility is on the soldier of judiciary how to check the orders of the executive, legislature, and the other organs of the state. Undoubtedly, there is a separation of power, and all the power, separation of power, like all the organs of the state are of equal status. But judiciary has been given a special status, because it is the judiciary who is scrutinizing all the orders passed by other organs as per the Constitution. So, of course, the fairness of criticism on the judiciary is the benchmark and the hallmark, because if anybody can put a negativity on the judiciary, entire democratic system will be collapsed. No doubt, individual comment on a particular judgment within the limit of fairness is always permissible, as I said earlier also, but it should not be willful. It should not be meant to lower down the dignity and the respect of judiciary in the eye of the common people, because still the people think that judiciary is the last hope. Judiciary is the last bastion of hope. So judiciary has a special role in our constitution, and we have seen also the role of judiciary. Even the Justice Karan case, Calcutta High Court Justice, the Honorable Supreme Court has said that contempt of court is not for the protection of the individual judges. It is for the protection of the institution. So the court is absolutely clear that the institution must not be disreputed by the criticism. The criticism are allowed to be made, but it should be within the parameter of the constitutionality. One should not be permitted to transgress and to violate the constitutional provision which had been enshrined in the Constitution. So on one hand, the Constitution is providing you right to speak, but on the other hand, the Constitution is taking away the right also to the limit, because there is a limit defined, though it is not, again, it is not defined. There are so many things which have not been defined in the Constitution, but yes, by development of the common law, there are clarity which are emerging out of the certain definitions. So my point is very clear that judges also, individual judges, I am not saying as an institution, individual judges must also exercise their restraint on the sensitive issue. What has happened in our country is due to the after Nupur Sharma case is due to the awareness of the common people towards the institution. And individual comment of a judge on a particular case, definitely the people take it offensive. But in this case, I am telling you, these observations is against the law, according to my subjective opinion. According to my subjective opinion, I think really the trial is the most important. The trial, you are there to pronounce the judgment. And during the process of investigation, nobody is permitted to express something which is against the constitution, against the law. And according to me, whatever observation, whatever content which are coming into the media is undoubtedly questionable in a sense, to the extent that such a harsh word should not have been made. But yes, there is a remedy under the law. I think whosoever is offended must go to the Supreme Court and pray for the removal of the comment and all. But I think this comment is not a written comment, it was a verbal comment. How it can be removed, I don't know. And one thing which is very important, that the mistake by judiciary, by saying or by writing, is more dangerous, because it is never obliterated from the case law. And the mistake by the executive and legislature can be rectified by the way of amendment. But here there is no amendment. So it is a very serious issue. And I think that the court should have dealt it once for all. And such kind of thing never happens in the history, because what is happening is not only damaging for the institution, it is damaging for the entire judiciary, because the kind of people who are converging to criticize the institution is phenomenal. I mean, I don't think that it is required. If there is certain people are offended by the observation of the Honorable Supreme Court, the remedy is there, because every person in India is born with the inherent right to sue a person, right? So they can go to the court, they can file a case, they can file a public interest litigation. They say to the judges that, my lord, I am offended, so please reconsider the subject matter of my offense. Definitely some, I think, order may come, and that Supreme Court order is a law under Article 141 of the Constitution of India, and all other subordinate courts are bound to follow. So this is the important aspect, the fair criticism, the fair comments. I mean, these are again a subjective interpretation. I mean, objective interpretation cannot be possible, because objective interpretation can be possible by the court only. I mean, me, a person like me, cannot, interpret the law. And yes, interpret the law, but finally the stamp of legality will be done by the courts only, because my lord and my justices are the sole arbitrator of the constitutional provision. So thus I come to one conclusion, that the judiciary also should not be so sensitive to the comments of the common people, because now with the advancement of technology, everyone has a voice to speak. Everyone is saying something on the social media, on everything, even if they are not expert, even if they are not really knowing about the subject matter, because they are swayed by certain comments of the common people. The common people are saying, therefore, I should also say something. So in this era of technology, there must be a regulation, because unfortunately in our country there is no regulation on social media. There are a lot of really negative video are also being uploaded. It is mock video are being uploaded, but there is no regulation. The court has to be swifter to the threat of this social media, because it is spreading in the menacingly manner. I mean, I think that the court must be alive to the fact that if it cannot be regulated, I think every day the courts are flooded with the contempt of the court, petition only, and all other petition will be thrown out immediately. So my point is that the court should not be so sensitive, because there must be a regulation. I mean, apart from the contempt of court 1971, I mean, 50 years had gone by, there is no law. And contempt of court, let me tell you very frankly, Mr. Lal, there are thousands of matters which are pending. Even my contempt petition for 5 years in Delhi High Court has been pending on the public issue, and no order. only because, I mean, admittedly, the government has committed a contempt, but unfortunately, it has been pending and pending and pending. So, what my suggestion is that contempt of court should not be scandalized. It has to be within the parameter of the constitution. And as an individual, because as a judge, of course, you have power to do anything. But as an individually, I think one must to think, because the power costs more responsibility. So, in nutshell, what I'm trying to say, I'm not going into the judgment because several judgments, there are so many interpretations of every word and a very very reasonable definition or correct definition has been provided in those judgments. So I'm not reiterating the judgment of the court for the purpose of making you understand what is the contempt and how it is to be interpreted and how it is to be a person can be punished in civil contempt or criminal contempt. The contempt is a contempt, whether it is civil or a criminal. It is it is for the purpose of lowering down the dignity and majesty of the court. In a nutshell, it can be said like that. So my point is very simple, that there must be a balance between the right of the individual and the majesty and respectability of the court. And this balancing task has to be done by the court. And I think that with the emergence of technology, where every day there are thousands of judgments across the country, thousands of criticism, over those judgments, there must be a new law that has to be implemented and that has to be enacted by legislature in view of the social media, because 1971 of the Contempt Act, when it was enacted, the law social media was not available. Now it is a social media. So this is what I am of opinion, and with this I am leaving my thoughts to all of you for observation and scrutinization.
Okay, thank you very much, Advocate Sudhi, for giving very, very strong views. Although again, I will say it's a strong views, but balanced views. One side, Advocate Sudhi says that there is no clear-cut demarcation about what is fair criticism or not, and it is a discretion. So the other side, he says that the sitting judges and Nupur Sharma, although I don't wanted to take the name, but because he has already taken the name, he says that the observation which they have made is not warranted and it is wrong. According to Advocate Sudhi, this is as per the law, it is not correct because it's not a final order, and until they proved guilty, accused cannot be termed as this thing. So according to him, whatsoever is happening in the social media, new law is required, and he is criticizing social media. But I personally feel that why to blame social media when we always believe in one thing, that there was a proverb in Hindi earlier that Sahitya Samaj ka darpan hai. Similarly, nowadays the social media is reflecting what is happening in the society. So you cannot blame the social media. It's the thing in the society. What is happening in the society, the same thing is happening. The same two judges have given some orders in Maharashtra case, and everybody appreciated. And within the 2-3 days, the same thing. Same 1 week when they were in the vacation bench, they were sitting, and now this thing has come. So it all depends on that if you are liking a judgment or an observation, you are ready to praise, and if you are not liking, and if you think that it is not as per your choice, you are started criticizing. Whether it is correct or not, that has to be scrutinized by the Supreme Court. Yes, one thing is very clear, that something should be clearly mentioned, what is fair and what is not fair when we are talking about the contempt. Thank you very much, Advocate Sudhi, for giving your views. Now I would like to invite my next panelist guest, and he is Advocate Gagan Gandhi. Advocate Gagan Gandhi is the managing partner of Niti Nyaya Law Offices, New Delhi. After doing his graduation in mathematics and statistics from St. Stephen's College, he completed his management from Faculty of Management Studies, FMS, University of Delhi. He worked in American Express Private Limited in their Risk and Information Department before he decided to do law from Faculty of Law, University of Delhi. Welcome, Advocate Gagan Gandhi, on our show. Advocate Gagan Gandhi, you have heard what Honorable Justice Mehrotra as well as Advocate Sudhi has mentioned. And both have given, in one way, balanced view, although Advocate Sudhi is a bit more critical and direct about the Nupur Sharma's case, which is in front of the vacation bench. And but our honorable justice has given very balanced view. He says the criticism is required, but up to a limit. It should not cross the limit, and because we have to keep the dignity of the honor of the courts. Otherwise, it's very difficult for the situation for the democracy. Now, we would like to know from you. You are also very much involved in many cases and practicing in Delhi, appearing in High Court and Supreme Court. So we would like to know from you now your views on, can judges be criticized? Advocate Gagan Gandhi, please.
Thanks, Mr. Goel, for giving me an opportunity to be part of such a distinguished panel. And I wish all my viewers a very good morning. And I was listening to both the bench and the bar. So I have the actually privilege of getting best of both the worlds. Had the topic been then that can the judges be judged, my opinion would have been different. But the topic stands is that can the judges be criticized? So my stand is actually will be different. As far as Justice Mehrotra was saying that the criticism is welcome, but what is the kind of criticism actually? That is more important. Now, the liberty which has been granted is the fair criticism of the Judicial Act. Now, Judicial Act has nowhere been defined what is Judicial Act. Now, referring to the case in hand, which the learned friend was actually discussing about Nupur Sharma, these were the oral remarks made by the two judges. This is not part of the written order. This has not been captured anywhere on record. So this stands out of the purview of the Judicial Act, according to me. Now, criticizing those oral remarks, and these oral remarks are actually taking place on a daily basis. Some oral remarks are in the lighter moments. Some oral remarks are to do corrections. So everything cannot be recorded. Every course correction cannot be recorded by a judicial officer because he's handling the number of cases which he's handling in a day. It is actually impossible for him to make such kind of recordings in each and every case. So as somebody has rightly said that both the parties knows what is right and what is wrong. It is only the judge who is on trial. So keeping that in mind, it is very difficult. After all, he is a human being. So we should actually give him benefit of doubt while he is actually taking the proceedings. But yes, at the same time, if there is a judgment, we need actually to analyze the judgment. The judgment is something which needs to be actually criticized because judgment is actually lays down the law, and law is something which has to be debated, and law is something which keeps on evolving with the passage of time. So if we do not discuss, as Justice Mehrotra was pointing out, then we will actually be left behind. The essence of the democratic setup is the evolution of law. And as the society is progressing, as the technology is invading each and every space, so why we are witnessing these remarks actually, it is thanks to the technology. The judicial system is getting accessible to the common man, which perhaps 20 years ago, nobody could have imagined. These remarks, if they were actually made in any courtroom, nobody would have dared to capture it. Why it is getting captured is because of the technology. So we should be thankful. Now the courts themselves are opening up. They are making their doors accessible to common litigant. That yes, we are here for you. I will come to that in my later part, that why judiciary becomes important out of the out of the three organs of the state. But before that, the judiciary itself is saying that we are going live, like we are having live discussion, so that anyone and everyone can watch us. We don't want to keep that curtain. And the purpose of doing that is to become accountable to the people for whom this judicial system has been laid down. As far as the other two organs are concerned, that is the executive and the legislature, they are actually accountable because they are directly dealing with the public. unlike the judicial system. So to make it judiciary accountable, this is the way forward which judiciary itself has actually proposed. Now, to pick up few lines, to pick up few comments, to pick up few oral observations, and then making a hill out of this is actually, I think, is going overboard. I think it is misplaced. Because then what will happen is that judiciary, instead of opening its doors, it will revisit that what are we doing right thing? Because now my each and every moment will be captured. I will be trawled from morning till evening. That will become the breaking news, and it will give license to everybody in the country to point out fingers at me who has not been satisfied with my judgment or who is not satisfied with the present judgment. So that is not the future which we are laying down. So the very fact that there are mechanisms in place, so the structure which we adopted, subordinate courts, then higher court, and then finally the Supreme Court. Now there has to be finality to something. You can't be questioning every stage. You already have questioned in the subordinate courts, then appellate courts, and then you have landed up before the Supreme Court. So there has to be a finality to the dispute resolution. Otherwise, your dispute will keep on going on. So we should accept the finality, and this court has been accepted as the final court of judgment. Now, as both the learned friends were talking about, we are well placed to criticize the judgments, but we should not be criticizing the judges. So that will be actually going overboard. That will be stepping the line which we will be crossing, and that will send out a dangerous message to the society. Why? Because this is the final organ which people see, they have faith, they expect that their problem will be resolved. So not only they are the judicial forums, but they are the problem solvers. They are the problem solvers of the society. So they are discharging functions which, on one hand, they are weighing the mighty state, and the other hand, they are weighing the downtrodden, the farmers, the people who cannot afford to have access to the judicial system. So the obligation or the duty which is actually casted upon them is humongous. So we cannot undermine that duty which has been casted upon the judiciary. Now, if we do not keep that out of the ambit of the criticism or day-to-day criticism which we see in the political arena, which we see before the executive, then this third organ of the state, that is judiciary, will also be maligned in the same way. And then that faith which we are talking about. So there was a common thread which I saw in both the arguments was that the faith in the judicial system should not be eroded. So that is of paramount importance. So in order to keep that faith alive, we have to give them due respect. We have to give them the power. Yes. So, but our fathers of the constitution, they were wise enough to actually keep all the checks and balances in the system. So it is not that there is no checks and balance on the system. Yes. And there was a time in the country when country was witnessing the coalition form of government, when then the judiciary actually stepped in. Then we witnessed the judicial activism, because it was actually to fill the void which was created by the executive space. Now this country is witnessing a altogether different kind of political setup. Now we have a very active executive. Now this judiciary is actually facing a different kind of challenges. So it is actually time based. The judiciary has actually stepped up whenever the need actually arose in the country. So having said that, there is a saying that power corrupts and absolute power corrupts absolutely. So keeping that in mind, there are enough checks and balances which I see actually, despite all odds. So the answer to everything is that this is a democratic setup, and the answer to all ills of democracy is more democracy.
Okay, thank you very much, Advocate Gagan Gandhi. And Advocate Gagan says power corrupts and absolute power corrupts absolutely. But Advocate Gagan Gandhi has taken a very, very clear-cut stand, and he says that whatsoever has happened in this particular case of Nupur Sharma, if we are going to criticize the observations made, which are being made by the two sitting judges, it is not correct. It is not healthy. And if it will be like this, then the judges will start thinking about their own judgments, and it will be very harmful for the society as well as for the democracy. But he says that our constitution's forefather who has prepared the constitution have made very good checks and balances, so no one can do anything. And he has mentioned that the earlier government, when there was a crisis and when the judicial activism we have seen, and the present government, which is quite active, they say that they are facing, the judiciary is facing different type of challenges. So we must give respect to the judiciary system. And he says that Supreme Court is the final authority. So we should not try to scandalize something which will demean the importance and the reputation of the Supreme Court. Thank you very much, Advocate Gandhi, for giving your very, very strong views. And I'm sure that today you have taken a stand. According to you, we should not criticize the judges openly the way we are doing. It is not good for the healthy democracy. Thank you very much. Now I would like to invite my next panelist guest, and she is Advocate Avishi Dhaka. Advocate Avishi Dhaka is BA LLB Honors LLM. She is advocate in Supreme Court, New Delhi. She is a result-oriented professional with excellence in implementing training mechanisms to deliver desired output, seeking assignments in learning and development with an organization of high repute. Her areas of expertise are ability to balance priorities and coordinate work effectively, leadership skills, excellent analytical skills, and aptitude for figures, ability to stay calm under pressure, can analyze large amounts of information, good written and spoken communication skills, client care skills, sound judgment, organized and efficient, good project management, and team building skills. She was trained at Gurugram Cyber Crime Cell under Commissioner of Gurugram Police and Mr. Rakshit Chandan, cyber security expert, and dealt with police investigations in cyber crime cases, economic crimes, social media crimes, website crimes, mobile crimes, email crimes, etc., etc. Welcome, Advocate Avishi Dhaka, on our show. Advocate Dhaka, you have heard Honorable Justice Mehrotra, Advocate Sudhi, Advocate Gandhi, and they have given their views very, very clearly. Now, we would like to know your views on, can judges be criticized? Advocate Avishi Dhaka, please.
Good morning. Thank you, Mr. Lal Goel, first of all, for calling me in such a reputed webinar of yours, and the way I'm sharing the people, all the people. I want to thank all my co-panelists, and all you people have already discussed so far about the issue, can judges be criticized? In my view, a moderate form of criticism is okay, but the open criticism, the way we criticize the political parties, it is, we cannot criticize our judges of that to Supreme Court and High Court, people who are so much qualified, dignified in this way, because they are not democratically elected. They are judges. And we, have associated a sort of, a form of respect, dignity, apart from their perks and privileges. They are above the society, of course, and they maintain their dignity by way of, and we also take into consideration, you have seen in movies and the way we always act, the first thing is you keep your hand on Bhagavad Gita, that I am so and so, and I, मैं शपथ लेता हूँ कि मैं जो बोलूंगा सच बोलूंगा. That sort of confidence, just like God, next to God in human form, is for a judge. And it is for the judge, and you blindly say, whenever you are sued or you sue someone, that I believe in the court and I believe the judges will give the proper justice to me. So we cannot openly criticize that thing, because if you do not respect the judges and you criticize them just like a layman or anyone next door person, means you do not respect the justice of your own country, because they are not normal people. They are giving justice. They have studied law, they have practiced it, and throughout they have seen the society growing. And now we want them to know, stop seeing the TV, you should not read the newspaper, you might get biased. They had so much time to get biased. They have studied so far, not just the law as well as the society. They have seen growing. They know how person changes in time, so they can understand. While giving something, they named a political person in a case where it was a case of beheading a man who was a tailor and by people, and it was made a religious issue, which was if not dealt properly, could have been a catastrophe. So we are, judging on the basis of one thing, just one person, one judge. So far we have had so many judges who have taken action suo moto, who have taken action on just a letter, or taken the things to be a PIL in their own cognizance. So we cannot justify just one thing. And because it is platform, so on digital platform we cannot tell our judges to stay completely isolated. It is not practical nowadays. They too have family, they too have have to cope up with the things. So they need to understand, they need to educate themselves. If it is a thing that they might get influenced, but the other benefit is
Uh,
that they can
Advocate,
stop a
Advocate
catastrophe.
Dhaka,
They can
your
stop
network is not clear.
something
Advocate Dhaka, can you hear
from
me?
happening. They know that something is getting a develop.
Advocate Dhaka, can you
Hello.
hear me? Okay, yeah,
Yes,
your
I can hear
network
you.
is now your network is giving problem. Just see that you change either the network or you change your location, the situation. The network should be clear. Just see that, or no other device should be connected with the same network, or change the network if possible.
I think. Can you see me now?
No, we can see you, but your
Am I
voice was
audible?
now you are audible. Okay, go ahead, please.
Okay. So what I was talking is that judges, because nowadays they are not so much isolated. The other merit of that thing is that they can stop catastrophe like situations or something. They can guide the society better. That we know, we are already well versed with the facts of the society, and we understand your pain, agony and suffering, which is you are going through, which is political, financial or anything, or issues related to some sort of that they can very well guide the people. So here it was a case of beheading, and I understand that they named someone who was not related to the facts of the case so directly. So although the final judgment we are all waiting for, it was beheaded. And although we have Bangalore Code of Conduct, which we do not practice in our country, and but because it is made, and United Nation has recognized it, and it is being properly practiced in many developing and developed nations already. So I think judiciary should come out with some sort of things and measures for judges, apart from taking very strict steps like impeaching the judges in the parliament. They can come up with something sort of proper guidelines for the judges, proper code of conduct, and which not just for the judges, even for criticizing them in public. It should be made, because we as lawyers, we do not know how much we can criticize them, because sometimes we are also humans, and when the things don't come out our way, we tend to criticize them, or we tell them that they were, or maybe the judges are not in right mind to give such an opinion or a judgment against per se. So we should have a proper code of conduct for the same, for the whole society as well as the judges. And judges are human, we understand that, but we tend them to see them in a higher light, um, like we see doctors, So the same way we see the judges, and the judges are higher, they are selected. First they have to study, and then they, after so much pain and after so much experience, they become a judge. Apart from whatever we may say that it is a collegium which runs in 800 families, it is easy to say that, but once you become, you have very much high responsibilities to be a judge and to, carry out your duties with the same responsibility of being a judge. And independence of judiciary has to be restored, and there are various checks and balances by the government. And also, and there have been many cases which because of time shortage, I cannot just discuss over here. And we have many concepts of law, we have jurisprudence of law, which judges already, it is imbibed in them, we don't have to teach them, they already know the law. So what they do, sometimes their hands are tied, and what they do, they have to go through the law. They cannot just morally decide what is, based on their emotion. They cannot outrightly make it happen. They go through the procedure of the law. They give you another date to come and, present your case. Many times, if judiciary had not been independent, there would have been many ways, many chances where where we would have been governmentless or laissez-faire, but we are saved because of, good judiciary system. So everything has its pros and cons. When we talk about just, budding name in the society of a upcoming young politician, we cannot just say that people are mad or the judiciary is mad. No, we cannot just criticize them that they are not capable enough to deal with the situation and the changing society. Oh, then they just change the law. It's easy to say that, but they know what test is to be required to be, taken in the issue. What is the relevancy of the matter? What is the case? It depends case to case, circumstances to circumstances, and available data, available things, evidences or documents that you have in possession at that time, and how to use them, and how to check the relevancy of the matter. So they owe a lot of responsibility on their shoulders. And plus, whatever they will judge, what is the outcome in the society, how the people will deal it. So to keep everything in control, to see everything is going in a legal way and proper procedure, and how the people are going to deal with it who are not even lawyers, are they going to come in the public. So that's a major responsibility, and it is very much easy to say that you have perks and privileges, you were selected by the collegium, now your life is lavish, and you are a judge and you need to bring a balance. Of course, you are already balancing the scales, which is not an easy job. You have to stay neutral, and which is humanly impossible for anyone, I think. So thank you so much, I rest it.
Thank you, Advocate Dhaka, for giving your views.
Hello.
And Advocate Dhaka has
Am
one-sided
I audible?
praised. Yeah, yes. You have. So Advocate Dhaka has praised the judges and the judiciary in a very big way. He says that the judges are next to the God, and we have to give them the full respect and dignity, and they are not a normal person. Rather, she says that they are above the society. So she has mentioned many things about the judges. But one side, she says that the judges have to be also a bit reasonable when they are making, although in this particular case, she has said that whatsoever the judges have taken a stand, it's a very responsible stand, because it's a very sensitive issue, where that's why they have done so much. So now, whether whatsoever is right or wrong, that is a separate thing. But according to her, the judges should not be criticized by anyone, and if we want to criticize, it should be in a very reasonable manner, not openly or through the media. Thank you very much, Advocate Dhaka, for giving your views. Your internet has given some problem, but yes, still, I'm sure that you please see to it why the internet is giving, and especially in Delhi, if the internet is giving problem, how we are going to do the education, online education and online court, which are going on. Thank you very much. Now, my first question goes, and it's a very difficult for me to ask a question to a honorable justice. Otherwise, they are always supposed to ask the question. But my now question goes as per the format. And the question is sent by Dr. Naveen Gupta, is the director of Hindustan Institute of Management and Computer Studies, HIMCS, Sharda Group of Institutions, Mathura. He says, who is responsible and accountable. If I don't know what he means, I'm sure Justice Mehrotra will be able, Honorable Justice Mehrotra will be able to answer this. His question is, who is responsible and accountable? Honorable Mehrotra, can you give the answer for this question?
As said by our earlier panelist, judges are also human beings. They also go through the newspapers as well as they see the news on television and perhaps a personal talk with their family members, etc. So no doubt they can form an opinion and say something. But I'm very much sure that when a judge goes through the record while deciding a case, definitely he remains unbiased. He gives his best and without considering the scenario, what is happening in the society. So it is very easy to say that a judge's passed some remarks or they are biased. I'm still not believing this phenomena that the judges remain biased with any of the either party or with the government or opposition parties. Blaming a judge is really very easy. I'm just reading in these newspapers nowadays that the guilty, the culprit should be given, should be hanged immediately within a month or two by holding the trials as fast track court. We can see just the judge population ratio in our country. It is really very poor. Our state Uttar Pradesh stands with a population of more than 25 crores and we have only 2,500 judges, and that too in 3 layers: district court, appellate court, and then high court. Judge does not work alone in the court. It requires the help of at least 2 advocates from 2 sides for trial, some witnesses, expert opinion, police officers, and etc. Judge can issue summon only. There remains some leading advocates in each district and even in high court. They have lot of works with them, so it is not possible for one advocate to appear in all the courts at one time. So the judges have to adjourn the cases. Witnesses do not come in time, and all the blame goes to the judge. That even in the pictures, Tariq pe Tariq, we are assuming all the blame. We are acting like Mahadev, we are not deciding the case in time. So still I think to blame a judge is not good for the society. Thank you.
Okay. Thank you very much. Tariq pe Tariq says Honorable Justice Mehrotra, with a famous dialogue. But he is right that you have to create the infrastructure, proper infrastructure, more judges. But again, the question remains the same, Justice Mehrotra. Who is responsible? Someone is responsible. Why they are not appointing? Do you think out of 20 lakhs advocates population in India, there are no sufficient judges who can be qualified for the judges, or some ulterior motive, so that if they are not aligned with a ruling party, whichever party is ruling at one time, that's why they are not giving their names to be appointed as high court judges or something like that. Might be one of the reasons, which we will keep in the next round, next time, somewhere in the same topic we will keep about why they are not appointing the judges in time. When any institution is not appointing somebody, the judiciary takes a very serious view that why you are not appointing and why the person is not been appointed. But when their own case comes, nobody bothers whether the Supreme Court is not taking the care or the government is not taking against. So the question which Dr. Naveen Gupta has asked is a very, very relevant question. Who is responsible and accountable? This is one of the reasons. That's why the criticism is there. Thank you very much. Now, my next question goes to Advocate Sudhi. Advocate Sudhi, the immunity is necessary for a free judiciary, but it is making them to some extent irresponsible. Do you agree with this? Please unmute.
Perhaps, Mr. Lal, I have heard a enlightened observation of Justice Rajiv ji and Gandhi ji also, and Lady Advocate. It was a wonderful, divergence of opinion. But the common thread is there that the judiciary must be respected as a whole. And this is the only one institution which I have utmost respect. The manner in which I enter into the court, I have my head bowed down before the justice. So therefore, there is no manner of doubt in the mind of everyone that the judiciary is a sanctum sanctorium institution of justice. And we are not blaming any justices. We are not blaming any individual judges for willful remarks and observation. But yes, my only contention is that the responsibilities are on the both sides. If the judge is a responsible judge, the lawyer is also a responsible lawyer, and the common individual is also a responsible common individual. What I'm trying to say, what you said, that the more power, the more irresponsibility. Yes, it is an inherent weakness in the human being, and I believe we are humans, judges are humans, and moreover, what is important, that all are the consumer of justice. Judges are also consumer of justice in some way or the other, and we are also consumer of justice. So the justice is of a paramount importance, and we lawyers and judges are there to help the achievement of justice. So the responsibility are onerous, no doubt about it. Yes, there are chances of mistake being committed, and aberrations are all there. And in fact, really, the non-obstant clause and overriding provision in every act are there. So my point is very, very clear that what I have said in the beginning of my discussion, that there is a regulation. I must say to you that the law is a dynamic. The law is a reflection of the society. Sometimes the society changes before the law enacted, and sometimes the law enacted after the change of the society. So it is a reflection of the society. What I am trying to say, that every day there is a criticism of the judgment of the judges in the social media. Social media I am not really critical about. But I am telling you now, one is quite open to several winds of thoughts. And of course, sometimes, negligently or sometimes deliberately, some people speak something. But it should not be, thrown out of proportion. It must be within the limit of reasonability. And person should get into the soul of that criticism. It may be harsh, from exterior, interpretation, but from interior interpretation, it is not a criticism, it is a fair criticism. So the judges must be a broad-minded also. And I believe that as several judgment of the Honorable Supreme Court, the Honorable Supreme Court has clearly held that we judges are not so insensitive. We are sensitive to the current of thoughts in our society, and we are not taking every cases as a contempt of the court, right? Everyone has a right to express their opinion, but this expression of opinion must be confined to the reasonable limit of the constitutionality and the legality. And if somebody crosses the boundary line and Lakshman Rekha to the extent of damaging the reputation of the court, then the matter becomes serious. Then the matter requires a scrutinization of the by the court. It should not be, to that every judgment must be criticized for the sake of criticism. Yes, there are legal aspects to be criticized. Of course, you are free to criticize. But every human being has its own faculty to understand a particular word. So, therefore, because we have a catena of judgment of the Honorable Supreme Court, which I may not be agreeing with, but the core of the judgment must be respected. And I think there are three-tier hierarchy of the courts, the lower court, high court, and the Supreme Court. And I mean, every like sometimes the court upheld the judgment of the lower court, sometimes set aside the judgment of the lower court, and it goes to the Supreme Court. And Supreme Court, the same manner, sometimes uphold, sometimes really reject the contention. So here there is a plurality of thoughts. No one can disagree with this. Every judges are coming from the different background. Some is coming from different backgrounds. So of course, the judgment of a judge will be guided by the educational background, the social background, the cultural background. You cannot ignore this. So independent judges, if the judge is independent, I disagree, because judge may be independent, but there is a milieu, there is an atmosphere from where the judges are coming. So the judgment are bound to be in disagreement. Like I am coming from the different, social status. But what I am trying to say, the core of the judgment must be respected, because no judge, either from any part of the country, the law must be respected, and every judgment is in accordance with the law. So therefore, what I am trying to say, that the basic thrust of the contempt of the court, that the sanctimonious institution like a judiciary must not be disrespected. Otherwise, the whole democracy will be collapsed, because this is the one institution. This is one institution where every organ of the state look for legitimacy, for legality. So therefore, we should be absolutely sensitive when we criticize the judiciary. We should not be often on criticize judiciary. This is the finality of my observation.
Okay, thank you, Advocate Sudhi. Now my question goes to Advocate Gandhi. Advocate Gandhi, keeping in mind the latest what is happening nowadays on the Nupur Sharma case, do you think the judges should be more cautious, and some limits must be imposed to the judges, especially when they are passing some observations in the open court? After all, one side they are saying that we are going to be now live telecast all our proceedings. So once you are giving such types of observation, which are majority of the people, or those who are not understanding, or those who are understanding the implication of the observation, they are criticizing openly. So do you think some limits must be imposed to the judges, or it is not required? The public should be restrained, and whosoever is criticized about this latest Nupur Sharma thing, they should face the contempt. What do you say about this, Advocate Gandhi?
So as far as the oral remarks by judges is concerned, the judges usually observe self-restraint, and they are after all human beings, and we cannot expect them to discharge their judicial functions mechanically. And what I mean by that is that they are also somehow connected to the issues. And then by raising such kind of questions, are we not questioning that they should become insensitive, that they should not be affected by what is happening around them? Because they are not functioning in isolation. They are part of this society. They are functioning in consonance with the other organs of the state. But yes, why their oral observations also do matter is because of the fact that it is not coming from anybody else but a Supreme Court judge. So yes, as far as the oral observations, oral remarks are concerned, they definitely need to observe the self-restraint, because it carries weightage. It has an effect on the trial proceedings, and someday down the line, people tend to start relating with those remarks, although those remarks have never been captured in the written order, or they were never made part of the judgment. But yes, there is observations in some judgments which take the form of an obiter dicta, but then we cannot rely upon those observations. They are observations of the judge, but that does not become the law of the land. So if there has been any observations, then it should not be read into letter and spirit.
Okay, thank you, Advocate Gandhi. Now my question goes to Advocate Dhaka. Advocate Dhaka, there is a statement by some concerned citizen about this Nupur Sharma case. Okay, and that consists of former judges also, and bureaucrats, etc. I will just read the first para, and then I want your comment on that. We as concerned citizens do believe that the democracy of any country will remain intact till all the institutions perform their duties as per the Constitution. Recent comments by the two judges of the Honorable Supreme Court have surpassed the Lakshman Rekha and compelled us to issue an open statement. I am not reading the open statement. You all know that. Now, question is Lakshman Rekha. Do you think now time has come that a Lakshman Rekha has to be defined, that what a Supreme Court judge should speak or not speak, and what a general public or anyone can speak against the judges or criticize the judge or not to criticize? What do you say about this, Advocate Avishija?
On this, Lakshman Rekha has always been part of, a part of, healthy and a proper boundary like thing, which cannot be crossed like that or by anyone. It is always as a safeguard used for the protection of the nation or the protection of the honor and dignity of the things or the people or the rights concerned about the people whose rights are at stake. Lakshman Rekha has always been a guard for that thing. So I think it is too early to judge the judges that they will, keep the Lakshman Rekha intact or not. Because till now, what we have seen, we have not seen that judges are openly partial, biased, or anything like that. It is too crucial for us to say, openly and criticize them for the thing which they have not done yet. But because one judge has taken the name of a political party leader in a case of beheading someone, beheading a person of one religious community, and beheading by the the perpetrators were from different community, and the situations were catastrophic. We cannot say that the judges in future will not be saving the Lakshman Rekha. It is their duty, it is their responsibility, and I think they will do it. And if they do not do it, the collegium in future will do something about it. When people will not have any faith in the judicial system, people will take the things into their hand. Why will they look at the courts? Why will they come to the court? Of course the court is going to do something, not just something. The parliament will make some laws if they do not do anything. Ultimately, checks and balances are always there and they will always remain. So this is what I feel.
Okay. Advocate Dhaka, okay, thank you very much. Now, in the last round, I would like straight answer now. Honorable Justice Mehrotra, my straight question to you is, in this present case, because we cannot now avoid that case, and that's why the topic is, do you think that the two sitting Supreme Court judges have crossed the Lakshman Rekha? I'm asking the same question again. And if not, then do you think all those who are raising the question, open statements, etc., they are crossing the Lakshman Rekha? What you want? We want, because ultimately someone, those who are, as Advocate Dhaka says, they are very educated. Oh, yes, no doubt about it. All honorable judges are very educated. They comes from an elite family. Although, as per Constitution, no one is above anyone. Everyone is equal to everyone. Even the judges are also equal. But only thing is that we have to give the respect. But and in case if they have not crossed the Lakshman Rekha, then those who are crossing the Lakshman Rekha, they should be giving a clear message. Otherwise, what is happening to this country of 130 or 140 crores people? They think that today, if somebody can criticize, he might be a ex-bureaucrat or ex, then I can also criticize. What do you say about this, Justice Mehrotra?
साइलेंट जजेस को कभी बहुत अच्छा जज नहीं कहा गया है. जजेस को इंटरेक्शन करते रहना चाहिए ड्यूरिंग द कोर्स ऑफ आर्गुमेंट विद द एडवोकेट्स आल्सो, क्योंकि अगर हम साइलेंट होकर बैठेंगे तो एडवोकेट कभी नहीं जान पाएंगे कि हम कहाँ पे कंफ्यूजन हमको हैं, क्योंकि एडवोकेट्स दोनों साइड से आर्गुमेंट करके हमारे कंफ्यूजन को दूर करते हैं. लेकिन बहुत से, जैसा कि अभी हमारे पैनलिस्ट ने कहा, प्रीवियस पैनलिस्ट ने, इन्वेस्टिगेशन के दौरान जब इन्वेस्टिगेशन किसी केस का पुलिस करती है तब कोर्ट्स उसमें इंटरफेरेंस इन्वेस्टिगेशन में नहीं करती है, और हमारे बहुत से कंडक्ट इन्वेस्टिगेशन को इन्फ्लुएंस कर सकते हैं। ये सच है कि जैसा कहा गया कि जजेस पार्ट ऑफ द सोसाइटी हैं, और बहुत सी चीज़ें वो न्यूज़पेपर से, सोशल मीडिया से, अपने फैमिली मेम्बर से, या बाजार जाकर जब खरीदारी करते हैं शॉपकीपर से बहुत सी इंफॉर्मेशन वो गेदर कर देते हैं। तो कभी कभी आउट ऑफ एंजाइटी या ओवर रिएक्शन में कुछ चीजें, एक्सप्रेशंस आपके कुछ ऐसे निकल सकते हैं कोर्ट में, लेकिन आई एम स्टिल श्योर कि जजेस जिसमें जजमेंट करते हैं वो फाइल देख के ही करते हैं। इन सोशल मीडिया के या न्यूज़पेपर के की इंफॉर्मेशंस उन पे कहीं भी हावी नहीं होती हैं। प्रेजेंट केस में ये सच है कि जजेस को इतना, बेंच को मेरी अपनी राय में इतना नहीं बोलना चाहिए था, कुछ ज्यादा वो बोल गए हैं। कुछ ऐसा लगा कि शायद उनकी नाराजगी है जिसको अवॉइड करना चाहिए था।
जी, बट व्हाट यू से अबाउट दोज हु आर रिएक्टिंग अबाउट अगेंस्ट दिस?
वो बहुत ही अनफॉर्चुनेट है, वो बहुत अनफॉर्चुनेट, क्योंकि वो सिस्टम को, देखिए अगर ये हमारा सिस्टम खत्म हो गया तब एनआरकी शुरू हो जाएगी, क्योंकि आज भी लोगों को फेथ है। देखिए एपेक्स कोर्ट आज भी हमारी, अगर एपेक्स कोर्ट के ऊपर भी कोई कोर्ट बना दीजिए तो हो सकता है कि एपेक्स कोर्ट के बहुत से जजमेंट्स अपील में सेटिसाइड हो जाएंगे। तो आपको कहीं तो जाके, आज हम लोग चाहे किसी रिलीजन पे चर्चा करें, एक हम लोगों ने गॉड मान लिया है और मान के चलते हैं कि चलिए गॉड विल डिसाइड इट ओवरऑल, तो कहीं पे जाके हमको फुल स्टॉप लगाना पड़ेगा, किसी की बात को अल्टीमेट डिसीजन मान के हमको एक्सेप्ट करना पड़ेगा। और डेमोक्रेसी में इसीलिए सुप्रीम कोर्ट को उन्होंने लास्ट रिसोर्ट माना है, मे बी अगेंस्ट द गवर्नमेंट, मे बी फॉर द गवर्नमेंट। चाहे नाराजगी आपको परिवार से हो, चाहे नाराजगी गवर्नमेंट से हो, चाहे नाराजगी सिस्टम से हो, एपेक्स कोर्ट के जजमेंट के बाद आप मान लेते हैं कि ये हमारा फेट था, ये डेस्टिनी थी। तो इसलिए एपेक्स कोर्ट को इतना आप अगर क्रिटिसाइज कर देंगे, जजेस को डिमोरलाइज कर देंगे, जजेस के मन में अगर कोई फियर आ जाएगा, तब शायद उनको इम्पार्शियल होके काम करना मुश्किल हो जाएगा, और वो डेमोक्रेसी के लिए अच्छा नहीं होगा।
Thank you very much, Honorable Justice Mehrotra. Advocate Sudhi, only one. Do you agree what Justice Mehrotra said? Yes or no?
I may not be monosyllabic in my answer. I have to be polysyllabic in my answer, right? So yes and no is difficult because I'm in a habit of explaining, right? So bear with me 1 minute, right?
Okay.
What Mr. Justice Rajiv ji has said is absolutely correct, because the observations sometimes made in the court are having impact on the legislature and executive also. So sometimes it is for the benefit of the society as a whole, and sometimes, yes, in this case, it is it has not been done in a proper manner. So what I am trying to say that हमारा जो मंदिर है, सुप्रीम कोर्ट में मैं जाता हूँ तो लिखा रहता है लोगों है कि ये तो धर्म तत्व गया, कितना बड़ा दर्जा दिया गया है। I mean, this Supreme Court is like this, and there are two type of justices in our country. One is activist judges, and the other is restrained judges. So activist judges has been the reason for the revolutionary changes in our society, like Justice Krishna Iyer. I mean, Justice Ashok Bhushan recently retired judges. They have done contribution to the society by making observation, and the legislature had made a law also, based on the observation that yes, there can be a law on this. So my point is, yes, sometimes judiciary makes an observation which is of course really fundamental towards the change in the society, and sometimes it is a subject matter of criticism, and I think really both should be balanced.
Okay.
So
okay. Thank you, Advocate Sudhi. Advocate Gandhi, do you agree what Advocate Sudhi says? Sometimes the observations change the society. Means the observations made by the two sitting judges of Honorable Supreme Court might have made this observation to pass a message that the society should remain calm and peaceful, not making any observation which can create some problem. Do you agree with this, Advocate Gandhi? Time is very short. 30
Yes,
seconds.
I will not take much time. And so, as legal practitioners, we every day witness, every moment we witness the oral observations being passed. So it is not something new which has cropped up in the Supreme Court. The only thing which is new this time is that it has been blown out of proportion. And why it has been blown out of proportion is for the reasons best known to whosoever has done so.
Okay. Okay. Thank you, Advocate Gandhi. Last, Advocate Avishi Dhaka. Do you agree that these observations have been blown out of proportion, as Advocate Gandhi said? Advocate Avishi Dhaka, can you hear me? No, I think she is. Yeah, she's there. Yeah, please.
Yes, I can hear
Please,
you.
please say. What you say about that?
Well, the whole matter is blown out of proportion. It is highly political, and it is not safe to say anything because the person who made a remark politically was a person, making not just a remark. She is young. She has a lot of potential to grow, and she might be a chief minister very soon of some place. So
Okay,
people
thank
are
you.
making not just remarks, and people are also.
So you are giving a message that by criticizing someone or do something, you can become the chief minister. That is the unfortunate part. I think we should not divide the society at all.
I
Anyway,
did
thank
not
you.
say anything.
But you said
I
that she
did
is
not
going to
say
be the.
anything.
Anyway, thank you
Okay.
very much. Thank you very much. So, viewers, you have seen today that all our panelists, expert panelists, have very, very clear message. Whatsoever is done, it is always for the benefit of the society. The judges sitting in apex court, the Supreme Court, they are not against the society. They are taking decisions very, very carefully. Even if they are making some observation, their observations are for the benefit of the society. Even if you are not agreeing, might be sometimes they overreach, sometimes they overreact because of their social activities, their family, or they are seeing the social media also. But then also to react in such a way or to criticize the judges is not acceptable. Because if you will start criticizing everything, every observation, then how they will be able to function independently? After all, we have given them the status. They are the apex court. There is no other court above them except the God. But if we have given that importance, if we have given them that dignity, we all have to keep the dignity. Yes, one thing is clear, even the Honorable Supreme Court judges also should see the atmosphere. They should also restrain somewhat so that no one can question their observation at all. Judgments, yes, it's a matter of criticism, one can criticize. Thank you very much. And today's program has been live telecasted by V4 News, Karu News, V4 Stream, Malnadu TV India, Newsgaon se, Samvad Sarocar News, Bharat Post News, Gyan, as well as shown live on Facebook and YouTube. And our endeavor to bring to you every day new topic in media conference with Lal Goyal at 10:30 a.m. Tomorrow, our topic is again a very controversial topic. And I would like to tell you that tomorrow, whomsoever I was talking, initially they says yes, once they listen the topic, they back out. And the topic is parents versus in-laws. I think Advocate Avishi is smiling. And our panelists are Miss Urvashi Mittal, MMS CFA, District Secretary, Innerville, District 301, New Delhi. Miss Parul Jindal, Director of Narayani International School. She is also the member of Advisory Forum, Aligarh Smart City, Aligarh. Dr. Ritika Garg, founder and designer of the Orki Boutique Jewelry, Jaipur, as well as Miss Brinda Shine, Director of SNP's Consolidated Column. So please tune in tomorrow to listen about parents versus in-laws because so many cases are coming to the courts because of this problem, parents versus in-laws. So at 10:30 a.m. Thank you very much, Honorable Justice Rajiv Lochan Mehrotra. Thank you very much, Advocate Shashank Dev Sudhi. Thank you very much, Advocate Gagan Gandhi. And thank you very much, Advocate Avishi Dhaka, for joining and giving your balance and the correct views. And thank you all the viewers for watching our show. I'm sure today's program is very enlightening. And I'm sure that we all will keep ourselves a bit restrained to criticize our honorable judges, whether they are